through all of that evidence and compare it to the instructions. The court, I think, has informed you, and you'll hear it again. The state has the burden. That is properly the state's burden, and the state accepts that burden. But what that means is I am responsible for proving to you every element of every crime that has been charged. So we have to take some time to do that. And then at the end of this, because it's the state's burden, we get to talk to you again. I promise you the second time will be much shorter. But if at any point during the course of this, someone needs a break, you can't hear something, you just need to stand up, please catch our attention. We will plan to take a break, but we want to make sure that if someone needs that earlier, you let us know, okay? So I have slides. Everybody processes information differently. Lots of you take notes. You can see that the attorneys take a lot of notes too. Some folks are much more auditory processors, and some folks are very visual processors. So I've tried to give you a number of different ways, as the court has during the course of this as well, of processing that information. If slides do not work for you, then please ignore them and don't pay attention to them. It helps me stay on track. It helps me present it in a more organized fashion, but that may not work for everyone else, okay? So don't feel like you have to pay attention just because they are there. Make sure that, there we go. So I always start with this first slide, lawyer statements. Lawyers talk a lot, right? It's what we do. You are going to hear, obviously, from the group of us, first myself, then Mr. Kading, then Mr. Leary, and then me again. What we tell you is not evidence. The evidence is the testimony and the exhibits that came from the individuals that were sitting in that seat over there. The attorneys will tell you things. We will argue to you the evidence we believe that you have heard over the course of the last several weeks. Attorneys are human too, and whether it is myself or Mr. Kading or Mr. Leary, what we tell you is not evidence. So if we misspeak, if we say something that we believe a witness has said or we recall a witness having said, and that does not jive with your memory of those events or your notes or your recollection, your memory, your notes is what the evidence is. We are not the triers of fact. We are just the attorneys, okay? So please rely on the instructions you've been given by the court and your recollection in those notes. So evaluation of the evidence. We provide this instruction also as well. Oftentimes you will hear folks during the course of whether it's a TV show or an argument or something else. Well, it's just circumstantial evidence. It doesn't mean anything. That's an inaccurate statement. When you come in, at least in the state of Washington, when you come in here, you do not come in here in a vacuum of life experiences. We want a fair and impartial jury, both for the state and for the Alis. We want to ensure that that is what you are there to do, but we do not assume that you have no life experiences and you cannot process information about what is reasonable behavior, what is unreasonable behavior, and reasonable inferences to take from those. So in Washington, we give you that distinction between direct and circumstantial evidence. Direct evidence is that thing that you have directly perceived. Circumstantial evidence is the thing that you know and you can make a reasonable inference from. So let me give you an example of that. And we use a cake example very often, right? If you go in and you make a cake, everyone who's ever made a cake knows you cannot frost a hot cake, right? My bakers know that. That frosting is going to slide right off the side and be a gooey puddle. It will look nothing like what it's supposed to do. So if you make your cake, you have to let it sit out and cool. So now let's say that you've made that cake. It is sitting out, it is cooling, and you live alone, you live with your dog, and you have errands to run. So you lock your doors, your windows are all locked, nobody else is there. You come back a couple hours later, and what was once a beautiful cake waiting to be frosted is now in shambles on the floor. There's crumbs everywhere. Your dog looks comfortably full, and there's crumbs all over the dog's face. Direct evidence would have been a video watching your dog eat that cake. Circumstantial evidence is exactly what we've just described. You know your dog ate the cake. That is the only reasonable inference that comes from that evidence. You didn't see it, but you know that that's what happened. There's no other reasonable explanation. No one's broke in. You said no one lives there. There's no windows. That's what happened to your cake. That is circumstantial evidence. And that is in large part why we provide you this instruction, but we trust that you are going to use your rational mindset and your common experience to know what facts and inferences to take from the evidence that you see. There may be differences in types of evidence that you receive, but the fact that one is circumstantial and one is direct makes no difference in terms of the weight that you give it, just by definition. So please don't get stuck in that loop in deliberation, like, well, it was only circumstantial, or oh, it was direct, so that's better than this kind. That's not the case. Like I say, that individual piece of evidence may have a different weight, but that weight is not drawn from whether it is a piece of direct evidence or a piece of circumstantial evidence. Okay? So evaluation of the witness testimony. Our way through those. In addition to the fact that you are the triers of fact, the sole triers of fact, you are also the sole judges of credibility. The attorneys are not. We cannot comment on the credibility of witnesses. We can point out whether there was a particular manner about a witness testifying, whether there was a personal interest, whether there's a reasonableness of the statements that they may have provided to you in context of everything else that you saw, but you are the sole judges of credibility. So when you are looking at the testimony of witnesses and how to evaluate that, you are given an instruction about some of the things that you can look at to help assist you in that process, okay? Reasonable doubt. Before you came into trial, if you've never sat on a jury before, but before you came in here, I believe that you would probably describe yourself as reasonable people. Most people would describe themselves as reasonable people. Having sat in here now and gone through all of these instructions, I would submit to you that we have ruined you with the law. You are no longer reasonable people. When you go back home and you're talking to friends when this is all over, or talking to your family, when the court has released you from your instructions not to talk about it, you can say, well, I don't know, I had a reasonable doubt that we didn't convict on A, B, and C or at all because I had a reasonable doubt. Or we convicted them on A, B, and C, or we convicted them on all because we had an abiding belief in the truth of the charge. Nobody talks like that. Lawyers talk like that, right? But now you will talk like that, at least as you are evaluating this and in talking to each other in that back room. So what does reasonable doubt mean? And you have the instruction. I submit to you that reasonable doubt and abiding belief are two sides of the same coin. If you have an abiding belief, then you do not have a reasonable doubt as to the truth of the charge. An abiding belief is abiding, long-lasting. You believe it today, you believe it tomorrow, you believe it next week, next month, next year. That is an abiding belief in the truth of the charge, that the defendant did what the state has charged them with, and that the state has proven that beyond a reasonable doubt. You have an abiding belief. If you have a reasonable doubt, then you cannot have an abiding belief in that truth of that charge, right? So it is not, there's no numeric value that you can apply to it. It's not a 51% or a 75%. Reasonable doubt is one of the highest standards, certainly, that we have, and we talked about that during voir dire, but it is not 100% either. So there is no numeric value associated with reasonable doubt. But as it says, if you have an abiding belief in the truth of the charge, then you do not have a reasonable doubt. And it's just another way of, I think, talking about that and evaluating within yourself. It's kind of this, amorphous is not the right word, but we as humans really like objective measurements, and there's no objective measurement associated with reasonable doubt. So you really have to look at this standard as you're talking about it and thinking about it amongst yourselves, whether it has been achieved, okay? Things you will not get. The court told you this just now in the instructions. Ms. Zoe talked to you about it during opening arguments, or excuse me, opening statements, if you recall. You are not going to get certain documents. And that I know is frustrating every time for a jury because people have referenced them. But the reason that you don't get them is exactly what we talked about, because the testimony is the evidence. A police report is not evidence. If that were the case, we wouldn't call anyone into court. You wouldn't hear from witnesses ever. We'd have them write a statement, you'd have police reports, you'd get doctor's reports, and you would never have anyone come in and testify. In the law, we value the testimony of people who are coming to tell you what they saw, what they heard, what they observed, what happened related to these events. And that is why the testimony comes from the person sitting in that stand. That's why you don't get police reports that officers have made along the way. You're not getting medical reports because the doctors came and told you what is contained within those reports and told you what they observed. Prior statements of witnesses, you don't get those either, right? That's why we have cross-examination, why we have direct examination. So please don't ask for them because they are not coming. You have to make your decisions based on the information that you have heard and what you have received as exhibits. And as we go through this process, right, talking to each other. And then last, of course, transcripts of any trial testimony. You're not getting any transcripts of, can we get a transcript of what so-and-so said on such and such day? That's not coming either, okay? So as you are going through and organizing your thoughts, please keep that in mind. There's a lot of overlap. So I'm going to tell you that there is approximately, if I did my math right, 11 different crimes that I have to go through and describe to you. There's a lot of overlap in that evidence. So I've tried to break it down as we go through those crimes where there is a overlap between both parents, and then we'll separate out some of the parents. So let's start first with count number 1, attempted murder in the second degree of that victim, Fatima Ali, for both parents, Ihsan and Zara Ali. Attempted murder in the second degree. I think it's instruction 14, I believe, gives you what it looks like if there is a completed murder in the second degree. Please do not get caught up in that is what the state has to prove. That is not the case. Instruction 14 shows you what completed murder in the second degree would look like. Instruction number 15 tells you what attempted murder looks like. If they were to have done this and completed it, this is what the state would have to prove. Instruction 15, I believe, is the one that says, but here are the actual elements that the state must prove, and that is a substantial step. A substantial step needs to occur. So a person commits the crime of attempted murder in the second degree with intent to commit that crime. He or she does any act that is a substantial step toward the commission of that crime. Okay. There is the completed murder in the second degree. A person commits the crime of murder in the second degree when, with intent to cause the death of another person, but without premeditation, he or she causes the death of such person. Then you are given what I'll call a bunch of definitional instructions. This one is as to the mental state. So intent, a person acts with intent or intentionally when acting with the objective or purpose to accomplish a result that constitutes a crime. Here's your definition for substantial step. A substantial step is conduct that strongly indicates a criminal purpose and that is more than mere preparation. It's not simply thought, but it is an act in furtherance of that intent. So these are what we talked about initially. The defendants are charged with attempted murder if, and I don't know that my red, it's a giant red dot, so you can see the if underneath, right? If the defendants were charged with a completed offense, this is what the state would have to prove, right? But because it is attempted, this is what the state actually has to prove, that on or about October 18th, the defendant did an act that was a substantial step toward the commission of murder in the second degree, that the act was done with the intent to commit murder in the second degree, and that any of these acts occurred in the state of Washington. And then when we talk about Zara Ali, the only difference between Ihsan and Zara is that Zara is charged as a principal or as an accomplice. Ihsan is only charged as a principal. Zara is charged in both fashions. So principal, you do it yourself without any help, or accomplice, that you were doing it to assist. You're assisting another in reaching their goal. So let's talk first about elements 1 and 3 for both parents. When we talk about elements 1 and 3, there's going to be, as I said, overlap. These are the elements that I anticipate there's not going to be a lot of argument from. I still have to prove them to you. The state still has, beyond a reasonable doubt, responsibility for proving these, but defense counsel, don't believe is likely to argue that it didn't happen on October 18th and it didn't happen in the state of Washington. So here's the evidence that applies for each of those, right? All testimony agrees that this was Friday, October 18th, 2024. You have the bus and the body cam videos that you saw that confirmed that. And then you have the testimony of the date and time of those school videos that Celeste Waltermeyer. We pull it and download it. Those dates are not shown on that video, but that's specifically the date, time range that I was looking and pulling from. And that information that you see in context on those school videos themselves from Timberline High School are consistent with what you see in context from all of the other videos. So I submit that that's accurate. She didn't pull a different date or a different time, right? Element 3, that these acts occurred in the state of Washington. This is Timberline High School. That testimony occurred over and over again. 6120, Mullen Road, Southeast, Lacey, Washington. And all of that testimony confirms the same. You're going to see this, a variation of this slide a number of times because it applies to every single count that we have, okay? So again, what exhibits do we have that demonstrate that as well? Here is exhibit 1. You have that bigger aerial photo. You have Timberline High School. You have the parking lot here. Now my red dot is covering towards the bottom center of that page where that bus stop is, and you have Mullen Road that runs diagonal across that page. Exhibit 2, bigger shot of the same thing. Again, at the bottom left corner, you have that bus stop identified. Mullen Road is identified. You can see that parking lot that we've watched several videos of throughout this trial. And you can see the crosswalk running diagonal across the
So not me. Let's see. Look like they got, of course, law and crime. What is going on here? Oh, here we go.
parking lot, but almost directly perpendicular up and down on this page with the white dashes running across it just to the left of center. Right? That's the crosswalk that we observe Fatima and during the course walking to the bus stop, and then again, people describing later towards the Timberline High School, which is outside of this photo, but would be at the very top of it, right? That's where those front doors are. So then we talk about let's talk about the rest of element 1, right? Remember, element 1 under attempted murder has a couple of different things within that element itself it has to prove. So the rest of element 1, speaking first to Ihsan Ali did an act that was a substantial step toward the commission of murder in the second degree. So what evidence do you have of that? What facts did you hear during the course of this trial? First, you have it. He grabs Fatima by the hoodie and places her in a rear naked choke. Let's be clear, the state is not asserting that Ihsan Ali showed up on that day with the intent to try and kill his daughter. There was no premeditation that the state is asserting, but by the time Ihsan goes into these events, the state's position is that that has changed. His intent has substantively changed. He grabs her by the hoodie and he places her in a rear naked choke, and we've heard that described with specificity. He takes her to the ground. He holds her in that choke for an extended period of time. He ignores those repeated screams and demands of no less than 6 kids. There's probably more there at varying times, but there's approximately 6 that are there pretty consistently throughout that entire process. And 2 separate adults to release her. We see Mr. Denicola come up on the scene in his bright orange vest. We see later Josh Wagner arrive on scene, and they're all saying the same thing. They're all screaming at him to release her, to let her go. Denicola, I think even at one point, I submit when you watch that video, is pointing a finger, and he's telling you, he told you in his testimony, I was telling him to let her go, to release her, to let her go. And he was just doing nothing. He was ignoring me. So it's not just kids that are running around. There's no chaotic panic. These are adults that are watching it happen and very clearly know that this is wrong. They're screaming that she can't breathe and he's killing her. And you hear that on the video. He continues to hold her while she fights and struggles. There's an apparent seizure. She goes limp, and then she is unconscious. The testimony by everyone is that her eyes have rolled back in her head. Her face is pale. Her lips are blue. And I believe Josh Wagner says she has changed colors. When asked on direct examination, Mr. Wagner, based on what you observed, and you came to it towards the end, based on what you observed, is there any way that could have been confused with hugging or simply restraining that child? And his response is no, it's very obvious she was being choked. That was Josh Wagner's statement. And then you have Exhibit 61, which is Elijah's video that shows you exactly the same thing. So I submit to you that that substantial step towards murder in the second degree has been taken. So then element 2, that the act was done with the intent to commit murder in the second degree. So what evidence have you heard throughout this trial that shows that? First, he holds her throughout all of that and continues to hold her after. The only time he releases her is when Josh to release her. All of these things are happening. This is not a like, oh gosh, it happened so fast, I had no idea what to do. It is an extended period of time, and he continues to hold her. Denicola, remember, he testifies that his arm is straining around her neck, that Ihsan's arm is clearly, there is a tension there. His hands are locked. Mr. Denicola's statement was, when asked, how do you know, what did that look like? And he was like, it was the look on his face. So he is there with them on the ground, and Ihsan's face clearly demonstrates to Mr. Denicola the intent behind what Ihsan Ali is doing to his child. It is so upsetting, in fact, Mr. Denicola testifies towards the end that he calls his supervisor to call it in, and says he is in shock. He's trying to process what he just saw, and he has to pull the bus over on the side of the road, and his supervisor has to come take his route. That is how upsetting. This is not a group of kids that are just overreacting to a situation. That is how upsetting that event was to Mr. Denicola. And he's described, I have security camera on my bus. I've had to look for a bunch of things, fights, whatever. He had to pull his bus over to process what he saw here because it was so upsetting. So what does that tell you? How is this different from the objective observer that doesn't know any of these individuals from Adam about what he observed from Mr. Ali's intent? That it was an intent to commit murder, not something else. You have Caleb talks to you about what we're trying to get him off. In fact, I'm pulling so hard at his arms that he tears Ihsan's coat, and still he doesn't release. Nothing changes. And you see evidence of that coat tear later. It is shredded down his arm. Ihsan doesn't let go. He is holding on to Fatima's neck throughout. He releases only when he is physically forced to do so, despite, and go back and watch the video I submit to you, she has stopped struggling for approximately 15 to 18 seconds prior. She's unconscious, and he continues to strangle her around the neck for another 15 to 18 seconds, and would have continued to do so even longer, but for the intervention of those adults. Then you have Dr. Gilbert's testimony about the effects of strangulation on the body what happens, and why that happens. She talked to you about the jugular vein inclusion, carotid artery inclusion, and tracheal inclusion. Remember, the lack of, starting first with jugular vein inclusion, the lack of removal of deoxygenated blood. Those are those thin-walled veins on the outside of your neck, right? You need the bad blood to come out of your brain so your brain can function. And we'll come back to the pressure, but it's about 4 pounds of pressure for that jugular vein inclusion, one on each side, thin walls. Then she talked about the lack of oxygenated blood to your brain. That is that carotid artery occlusion. Those are thicker walled arteries, and they are deeper within your neck, right? And that is greater pressure to close. She said about 11 pounds, I believe. And then she talks about what that lack of oxygen to the brain and that buildup of pressure does in the brain, how that leads to brain death, which is death. So then we talk about element number 1 for Zara as a principal or as an accomplice. So remember first, this is generally speaking what it means, that language principal or accomplice means. All assistance by words, acts, support, or presence, and present at the scene and ready to assist. First we have, well, let me back up for one moment. When we talk about principal or accomplice, it's really obvious what principal is, right? You're the person doing it. You don't have any help. You're doing it sort of independently yourself. As an accomplice, if you're assisting someone else. And we distinguish, I'll give you a bank robbery as kind of the classic example. When we distinguish an accomplice in like a bank robbery identification, right? We want to talk about the people that are there to help assist the principal in doing whatever the principal is doing, generally robbing the bank. We want to distinguish that person from the customers that are present, that are there to do business. They know bank robbery is happening. They're present and they're aware, but certainly we wouldn't identify the customers as accomplices in that case. We would identify the getaway driver, the lookout, the other person who's providing the banking information or copies of the key. We would describe those people as accomplices. And even the lookout, right? They may not even actively touch anything. They may literally just stand at the door, but they are still identified as an accomplice. So that accomplice liability instruction, and you have it in your instructions. I don't recall the number off the top of my head, but that is what distinguishes somebody who's just present and has knowledge of what's going on from the person who is actively engaged in trying to fulfill the goal or extend the behaviors of the principal, right? All assistance by words, acts, support, or presence, and present at the scene and ready to assist. That is your accomplice liability instruction. So what do you have? You have Exhibit 34 at 2:13:57 on Exhibit 34, and that's that the bus video, the road view of that bus video. Mrs. Ali arrives at that tree. Josh Wagner, white line, he's still in the street on Mullen Road. Ihsan is struggling with Fatima, but Zara is already there. She is a couple steps ahead of Josh Wagner. 2 seconds later, same exhibit, you see that Zara is at the group. She is bent down with Fatima. Her arms are outstretched. Josh Wagner has just reached the dirt. He's not even at the group yet. So he's not there. He hasn't interrupted the strangling, but Zara is there. And Zara's not like somewhere else. Zara is right there. She is bent down with those individuals. These are separate acts and behaviors from those of the kids watching. Because what are the kids doing? The kids are still screaming, get off of her, like go of her, you're killing her. And what does Mary Wagner say? Mary Wagner says, Zara is not helping the young woman on the ground. She seems to only be trying to stop the teens from hitting the man who is strangling Fatima. She did nothing to assist Fatima from what Mary Wagner saw. That's, I submit to you, what you see on the video. It's fast. Remember that those videos go, they pause, they go in slow motion, and you have access to those to fully and fairly consider that. But she goes in and she immediately is pushing kids, but she's not providing assistance to Fatima. Neither Josh Wagner or Denicola describe any assistance for dislodging Fatima by any other adults. They're the only two that are in there trying to get Ihsan Ali's arms pried off of the neck of his daughter. No one else, in terms of adults, are doing that. Then you have Exhibit 122 plus Mrs. Ali's statements. She clearly expresses over and over again to law enforcement that her concern is for the kids that are hitting and striking her husband, not Fatima. In fact, she doesn't even mention that her husband has been strangling Fatima. But she's there. We know she sees it. Everybody else sees it. But she says not a word about how her child has been strangled into unconsciousness. And we know by the time she arrives, Fatima is unconscious. She is pale, her lips are blue, and she is laying still because there's only about a handful of time from the time that she gets there to the time Josh Wagner is able to get Fatima released. And what does Josh Wagner say? He immediately knows that a child is being choked. He doesn't say, when I got up, I could see that it was a child being choked. When I got out of the car and started coming across the street, I could immediately see this is a child that is being strangled immediately. And again, he doesn't know these individuals from Adam, but Mrs. Ali does. In fact, she's outside of Isaiah, is really the only one who knows exactly who is strangling and who is being strangled. And she doesn't mention a word to law enforcement. Remember what Officer Bell says. When asked, how long until you knew? He was like, at the end. It was basically to the end of my time there on scene before I had any idea that Fatima had been strangled. Because even though I had talked to mom and had interactions with mom, she didn't say anything about it. Not a thing. So we have to go through the accomplice liability and the principal for Zara. So element one, as an accomplice. What evidence do you have? As an accomplice, at 2:13:55 into that exhibit. And remember, that's the date time. In exhibit 34, it has the date time stamp on the bottom. So 2:13:55, Fatima goes unconscious. So we know she's already in that state by the time mom gets there. Her face is pale, her lips are blue. Ihsan is still actively.
Just so y'all know, that is not the host with the mostest. That is not me. That's definitely Court TV. Let me see what we could do about this, because that's not going to work, right? I'm watching it straight from Court TV's website. We have it playing. Let me put us back where she is talking. Give me 1 second. Let me see where this one is at as far as the minutes. Wait. Enforcement concern. Okay, give me 1 second, because I don't want us to miss any of it.
Strangling Fatima at that time. We said she knows what's going on because it's apparent to everyone else, immediately apparent to everyone else. And Zara is the only one that knows those individuals. And that she's attempting to intervene on behalf of her husband while he is still actively choking Fatima. Not Fatima. She's not attempting to intervene on behalf of Fatima. That is a substantial step. That is more than your presence and knowledge at that scene. We know that Fatima is not released by Ihsan until about 2:14, 10 to 13. so that if you look at that video and watch, somewhere between 10 seconds after and 13 seconds after, that is when we know Fatima gets released. So there's a period of about 11 to 14 seconds where mom is assisting Ihsan and not Fatima by trying to prevent assistance to Fatima from those kids. So again, as an accomplice, element 2 for Zara, that it was done with the intent to commit murder in the second degree, that she is actively watching her husband strangle her child in that rear naked choke with the arms tightly locked around her child's neck. She is actively able to see what every other person has described as Fatima's appearance throughout that time. She has time to view the situation and make a decision to try and remove impediments and prevent injuries to her husband. So we know she's able to quickly evaluate a situation and take actions based on her evaluations. To be clear, this is not a complicated fact pattern to evaluate when you have arrived on that scene. Everybody says so. Everyone that's present says so. Every other person immediately knows the danger, obvious danger of death to Fatima, but somehow mom doesn't. So what do we take from this? Her loyalty is to her husband and his purpose, not to her child. So then as a principal, what is the substantial step, the evidence you have of a mom as a principal? She's just watched her child being choked and unconscious for approximately 11 to 13, 14 seconds per that bus camera video. Fatima is then released. Josh Wagner gets her released. She is incoherent. Remember what Fatima says. The last thing she sees, remember seeing is Isaiah on her face and bushes. And the next thing she knows, she is in her mom's arms, and her mom has her arm around her neck. She is not there. Mary Wagner talks about that, like that girl is not there. Like I don't have another way to describe that. She just was clearly not aware of what is happening around her. She has come out of that unconsciousness. But she immediately wraps her arms around Fatima's neck. Her ability to breathe, Fatima says, I can't breathe. I'm trying to tell my mom, but everyone describes like nothing is coming out. There's no sound coming out. Denicola says he remembers hearing her being almost like raspy, whispery, but she wasn't really making sound. And plainly, he said, I wasn't looking at that. I saw what appeared would be a mom and the child, so I assumed they were fine. My focus is on dad because that's where the immediate threat was. And I was trying to pay attention to the immediate threat. But I remember hearing this very whispery, raspy. That is consistent with what Fatima told you that she was trying to do. Trying to tell her mom, I can't breathe. I can't breathe. And her mom doesn't let her go. So what happens? And the kids intervene as well. That's the substantial step. Dr. Gilbert, again, all of that same information about the effects of strangulation on the body and why. And certainly, if you've just been strangled for 45 seconds, being strangled a second time doesn't improve that condition. You don't start over from zero as if the first time it never happened. It is a continuation of that strangulation. So what is the information that the act was done with the intent to commit murder? Same intent as accomplice liability. That hasn't changed. She has actively watched her husband strangle her child. She's actively able to see what everyone else has described. She's had time to view that situation and make decisions to try and remove those impediments to her husband and prevent injuries. And she's had, at this point, when she is separately strangling her daughter, has even more time now, knows the danger, and does it anyway. She does it anyway. That is not an effort to comfort her child. Again, that is not where her loyalty lies in this situation. And she demonstrates that over and over and over again during the course of those videos. So here is that bus video. I'm going to play it in regular speed. You can play it whatever speed you want.
Nobody's just looking at the video that we can't see, of course. And I just want to thank everybody. Can you hear me now, therapist? Wake up, wake up, wake up, wake up. Potato underwater. I don't want to be a potato up underwater. Yikes. Okay. Well, I'm just gonna be quiet then. I'm gonna let y'all hear all the horn blowing and stuff that they got going on in my ear. That's what I'll do. But if you can't hear me, if not, I want to thank everybody for tuning in. I appreciate everybody. Y'all know what it is. I'm gonna put us back in. Here you go. Sorry, guys.
This is what you see from the backside, right? They've now run away. And this is the face of Isaiah and Fatima as they are running to the school for help. It is not the face, I submit to you, of children who are just goofing off, who just believe that they are trying to get away from their parents because they're going to get in trouble. Evaluate what that face looks like as Fatima's running away from her parents. Look at Fatima's face when she comes in Exhibit 111, page 3 of that, because it comes in a packet of still shots. Look at Fatima's face when she comes in that office. You heard Tracy Arnold testify that she looked like she was in terror. She was frantic. Submit to you that is consistent with what Exhibit 111 presents. Now you also have a instruction with attached to a special verdict form. Everything that is a -1, essentially, in your packet. You have a lot of verdict forms, you guys. Everything that is a -1 is what we'll refer to as a special verdict form, and you have to just answer yes or no. And that is essentially depending on which count it is Ihsan a family or household member, or is Zara a family or household member of Fatima? And here is the instruction that describes what a family or household member is. It's exactly what you would think it is, right? If you are a biological or legal parent-child relationship. So in terms of the elements, attempted murder in the second degree, family or household member, on special verdict form A1, Ihsan Ali is Fatima's father. Everybody says so. Fatima says so, right? In fact, part of the defense that has been provided to you is that they are parents, they are her parents, and so therefore they get to behave in a particular way. So I submit to you, this is not an argument between the parties. You still have to find it, again, beyond a reasonable doubt. The parties are not arguing about whether Ihsan and Zara are Fatima's parents. So the answer, if you convict on any of those charges, the answer on each of them should be yes. So now we're going to jump over to count 3, unlawful imprisonment of Fatima, again, for both parents. Your Honor, it sounds like maybe we need a break.
All right, I'm going to ask the bailiffs to come forward and we're going to take a recess for 10 minutes. Remember, you are hearing closing arguments and deliberations has not begun. You are not to discuss anything during this break. We'll be in recess for 10 minutes.
So hopefully I don't sound like I'm up underwater this time. I think it's when I be trying to keep them in my ear and not mute their part and unmute my part. And you know, I go with this old mute button. Y'all know, because depending on what time it is, I've been mute all this stuff up. So hopefully I sound okay. Cool. Thank you, OnlyFans. What's up, Jack? I know. Zach, you can't stay gone too long. Thank you, Zach. He demand a recount. I don't know. You gonna have to get up in there. Awesome, the Jews. You know, I want to make sure y'all hear this message loud and clear because I be spitting some stuff over here and then sometimes I'm on mute. I'm sounding like I'm up underwater, like, and I can't remember what I said. But y'all know what's up over here. We got that good old TiVo time, right? So we ain't got to worry about this little 10-minute break they call themselves on. We about to jump right back up in it. Give me a second. Let me put us right back here for these old closing arguments. Y'all, how do y'all think she doing so far? Is she piecing it together for y'all? Let me know. Yeah, it looked like a headboard that don't nobody want to sleep on. Don't nobody want that old-fashioned headboard. Look, headball. Wow. Welcome, Clearly. Thank you for anybody that's just joining us. Hey, keep it moving. Thank you. For anybody that I didn't get in the chat, trust me, I'm over here working it. Here we go, guys. I'm putting us back in after this break. Zach demands a recount. I'm counting, Zach. I'm counting. I need you to stay in here long enough, and then that way I can finish the count up for you. All right, guys.
Please be seated. Ms. Stone, you may continue with your closing argument.
So now we've moved on to count 3. We're going to skip count 2 for Mr. Ali. We're going to come back to that. As you can see in your instructions, there are some other instructions that follow along with that. So let's skip over to count 3 first. That applies to both Ihsan and Zara, and that is the unlawful imprisonment of Fatima. So you have the instruction that tells you what unlawful imprisonment is, how unlawful imprisonment is defined. I've highlighted for you the intent element, which is knowingly. Person commits that crime when he or she knowingly restrains the movements of another person in a manner that substantially interferes with the other person's liberty. If the restraint is without legal authority or without the person's consent, and the person knows that restraint is without legal authority and without the other person's consent. What is restraint? Restraint is without consent if it is accomplished by physical force, intimidation, or deception. You have that definition in your packet. I'll tell you, I don't recall what the number is. For those, I don't have them all committed to memory. And then you have knowledge. What knowledge is described for you. Throughout the course of your instructions, you have a number of different intent elements that are described for you, or mental states that are described for you. Knowledge, intention, doing something with intent, and as you'll see later, reckless. Okay? A person acts knowingly when he or she is aware of that fact, circumstance, or result. You don't have to know that the thing you're doing is a crime by an RCW. You have to know that the thing you are doing is the thing that you are doing. You are acting with knowledge that you are doing the act. If I walked over here and pushed Miss Zoe, I don't have to know that that is a particular type of an assault. I have to know that I am pushing Miss Zoe. Right? If a person has information that would lead a reasonable person in the same situation to believe that a fact exists, the jury is permitted but not required to find that he or she acted with knowledge of that fact. And when acting knowingly as to an element is required to establish the element of the crime, that element is also established if that person acts intentionally. So if I walked over here and shoved Miss Zoe, I know that I have to know that I've shoved her, right? Not like I tripped or somebody bumped into me and I had no idea that I actually bumped her or pushed her at the same time. If I walked up and 2 hands shoved her, if you agreed that I did that intentionally, then you also agree that I've done that knowingly. Intentionally is essentially one mental element higher than knowingly. So as it pertains to Ihsan Ali, that is your to convict instruction, count 3. You have that in your packet. We're going to come back to these. And then you have the same instruction for Zara, exactly the same, except again, it has for Zara that principal or accomplice language. That is the only difference between those 2 instructions in your packet. Okay. So again, those elements as it applies to both parents. Remember, I said that we are going to talk about what overlaps between them first. So what applies for both, don't anticipate that there is going to be an objection, or not an objection, a disagreement by defense counsel that happened on October 18th, 2024. I also don't anticipate that there is going to be a disagreement. Again, you still have to find that I have proven it to you, but that the defendant knowingly, and as to this element, restrained the movements of Fatima in a manner that substantially interfered with her liberty. You have to find it. I don't think the parties disagree that Fatima's movements were restrained. Ihsan strangles Fatima. She's unable to get away without help. Zara holds on to Fatima after, strangles her, would not let her go. Again, Fatima is unable to get away without assistance. So I submit that these are not going to be issues that are going to be really in contention between the parties. That restraint, as it relates to both parents, that restraint was without Fatima's consent. That is the testimony of everyone. She is fleeing her house and her parents. She has run away. She has been actively avoiding her family all day. Exhibit 34, you see that she is trying to run from dad. She is fighting dad. You have exhibits 74, 75, 78, 77, 81. You see all of those injury photos, and we're going to look at them in a little bit. but they show all those scratch marks to her neck. And you heard the testimony, I believe it was Dr. Gilbert, it may have been Lisa Wall, talking about she's clawing at dad's arms. And you hear all of the students talk about that. Clawing at dad's arms, trying to get him off of her neck. Clearly, that demonstrates a lack of consent by Fatima to be restrained, let alone restrained in that fashion. And then Fatima tells you too, she's trying to tell her mom to let her go. She is not consenting to her mom strangling her. She is not consenting to the manner in which her mom holds her. And I want to be clear, we're going to come back to it, or not come back to it. We're going to get to it in a little bit because you have a parental discipline statute. So it is not asserting that a parent cannot restrain their child. We know that that is the case, right? There are things that parents have to do to correct restrained children, but this is not one of them. So as you're starting with the initial baseline of whether this happens with Fatima's consent, it certainly does not. And you have ample evidence of that fact. And then you have exhibit. Mom is strangling Fatima around the neck at about 2 seconds in, grabs her again at about 8 seconds in. You have those screenshots. It's far away. It is harder to see, I would submit, but it is there. The location of mom's arms. You have that Fatima, you see her forward, and then you have her leg going up, and you see that she is being pulled backwards at about 6 seconds in. She is trying to get away. She is looking to Isaiah for help. Her balance is being pulled off, and that is mom who is holding her at that point in Noah's video. Again, that applies to both parents, that the defendant knew that restraint was without Fatima's consent. That's the testimony of everyone. Her parents know that she does not want to be restrained by them, certainly. And all of that evidence is exactly the same. Not only was it without her consent, but that same evidence tells the parents that they know that it is without her consent. They're not under the mistaken belief that somehow she's okay with it. And that any of these acts occurred in the state of Washington, same information that you had previously, okay? So what is the unlawful imprisonment as it relates to element 4 only for Ihsan? First and foremost, without legal authority. You cannot strangle your child to restrain them. It seems really obvious, but apparently it has to be spelled out. You cannot strangle your child to restrain them. Instruction 21 is the self-defense instruction for assault, but I submit to you it is instructive for explaining the limitation on parents' rights for either correcting or restraining your child. You forfeit your right to use parental discipline to restrain your child when you do so in this manner, when you strangle your child and impede their breathing. It should be obvious. The other examples given in that instruction, you can't burn your child. That should be obvious to correct them or restrain them. You can't throw your child. You can't cut your child. You can't punch your child with a closed fist. Those should be really obvious things as parents, right? You do not, that force is incompatible with the duty to care for your child as a parent. So you cannot restrain your child by strangling them and cutting off their air. That is not an appropriate use of legal authority. And element 5, as it relates to Ihsan, that the defendant knew that restraint is without legal authority. He knows he's not allowed to strangle his child. You go back to that instruction 32, knowledge, subjective and objective components to knowledge. There's a subjective, he knows all the facts that what he is doing is not simply restraining her movements, right? It says, based on the facts and circumstances known to the person at the time, he knows he is not merely restraining her movements. Everybody there says it too, right? They're watching it. It's his arms around Fatima's neck. That objective measurement, if a reasonable person in the same situation would believe that fact to exist, then you are permitted but not required to find that he acted with knowledge. A reasonable person, I submit to you, with all of those same facts and circumstances known to Ihsan at the time, knew that restraining her in that manner was not with legal authority. There's no good faith belief here that such use is reasonable or moderate. And the law does not require you to know that that act is unlawful specifically or an element of a crime, Doesn't require you to go to an RCW or a jury instruction element 5 and say, well, I didn't know it was that element, so therefore you can't hold me accountable. That would be absurd, right? You have to know that the behavior itself is wrong and without legal authority. So how does that apply then to Zara? Again, same information. You can't strangle your child to restrain them. She watches Fatima being strangled by Ihsan. She then puts her own arms around Fatima's neck. She's not comforting her. She's strangling her to keep her from fleeing. Her breath is impeded. Fatima's breath is impeded by that hold. She testifies to that and told the medical professionals, you heard that from the professionals specifically, that she reported that by her mom to the medical professionals. You look at that instruction 21 and those limitations on what parents can do to their children to discipline or restrain them. She's doing it both herself as the principal, and she's continuing her husband's actions for that same purpose as an accomplice. That the defendant knew that restraint was without legal authority. That information is the same as it was for Ihsan. And then again, how do you know that she knows that that's without legal authority? Her own statements. Her statements are about how people have treated Ihsan at the scene. She has talked about, where is my daughter? Give my daughter back. I want to see my daughter. And I want to see my daughter. I want to talk to my daughter. Right? Her focus consistently is on Ihsan. It's not on the health or care of her daughter, just location and access to her. That is all she expresses to law enforcement. So same thing, family or household member. This is your verdict form, C1. No change to that. Exactly the same as the last one. So now we're going to go to Ihsan Ali, count 2. And now that's the overlap between the two parents. Now we go to separate crimes for each of the parents. And we're going to start with count 2 for Ihsan Ali. That is that assault in the first degree. Assault in the first degree, the crime of assault with intent to inflict great bodily harm. He or she assaults another by any force or means likely to produce great bodily harm or death. And then you have the definition of assault. We'll come back to that. That will apply when we get to the assault on Isaiah. Touching or striking, harmful or offensive. Right? Great bodily harm. And great bodily harm that creates a probability of death. Bodily injury that creates a probability of death or significant permanent disfigurement or causes significant permanent loss or impairment of the function of any bodily part or organ, right? If you take somebody's eye, you're talking about great bodily harm as an example. Or if you use a measure of force that creates the probability of death if that force has not been otherwise interrupted. And that's what we're focusing on in this case. So you have those definitions, or excuse me, you have the overall elements. You're given that in your packet. There's 4 elements. So let's go through them. Well, we're going to talk about this first, actually. Physical discipline of a child that the force used was lawful as defined. We just kind of went through that. That force is lawful when it is reasonable and moderate, when it is inflicted by a parent for purposes of restraining or correcting. And you must determine whether the force used, when viewed objectively as a reasonable person looking at that same force, is that force reasonable and moderate? And that definition goes on, as I said, things that the law identifies as that you may consider unreasonable. Striking a child with a closed fist, interfering with the child's breathing. The other examples we talked about, burning, throwing a child, kicking a child, all of those things. As part of your determination of whether force used was reasonable or moderate, you shall consider the size, age, condition of the child, the location of the injury. Certainly, the smaller the person, the younger the child, the more concern there is for how that force is used on that child. It's not a binding inference, right? But that is an example of things that you can determine are. So that element, as it pertains to Ihsan, again, the things that I submit to you are not going to be in contention between the parties, right? October 18th, It's Fatima Ali and state of Washington. Those are not facts that people I submit are going to be arguing with you. Element 2 is where I think you're going to be focusing the majority of your discussion in this case as to this issue. So let's talk about the evidence that you have. Element 2, that it's committed by a force or means likely to produce great bodily harm or death. So first you heard from Lisa Wall, and you're going to see LOC because I run out of room in each of these, right? Loss of consciousness. What happens when you lose consciousness? Your muscles relax. The damage becomes easier to inflict, and the easier the damage is to inflict, the result is death. That is the next logical step following loss of consciousness, is death in that process. You have the exhibits from Synovia Rivas, 67 through 81. She talks about the symptoms that she observed immediately afterward during that exam: headache, dizziness, lightheadedness, again, loss of consciousness, memory loss, a fuzzy feeling. Fatima reported feeling fuzzy, confusion, weakness and numbness, vision changes. She says everything got dark. And you heard her talk about that. Hearing changes. She had ringing in her ears. She had neck pain, external neck pain. And you see all the bruising from that. You hear her talk about her sore throat, her difficulty and pain swallowing, those voice changes, the hoarseness. They describe her as hyperventilating. She was still hyperventilating after the fact. All the redness, abrasions, and bruising, and then the petechia around the eye that she describes. Fatima described a 5 out of 5 for pain, told Ms. Rivas she thought she was going to die, and it felt like it went on for 5 minutes. It felt really long. She said, I'm sure it wasn't. I know it wasn't, but it felt really long from where she was. And think about what Dr. Gilbert, when Dr. Gilbert went through and talked to you about what the effects were of jugular vein occlusion, carotid artery occlusion, tracheal occlusion. She correlated all of that to those symptoms specifically. Why do you get headaches? Because you have that buildup of pressure, right, in your brain. Why do you have loss of consciousness? Because there's not oxygen going to the brain, right? There's not bad blood coming out. There's not good blood going in. Why do you have memory loss or fuzzy feeling? Because all of that brain function has been interrupted as that process goes. She talked about the eye changes and the hearing changes because your brain stem is interrupted, and the ability for your brain stem to process and connect to the vision in the eyes is been interrupted and is unable to do so. Hyperventilating, we talked about panic. One of the natural symptoms, your body's natural reaction is to panic when it can't breathe, and that panic continues on until it no longer feels like it is in threat or fear. She's describing hyperventilating to Synovia Rivas while she's arriving at the hospital, still after the fact. She has not come down yet. Her brain has not taken that threat away so that her breathing has returned back to normal. Dr. Gilbert talked about all of those things. So then you heard also by the force or means likely to produce great bodily harm. You heard from Dr. Kim, who was not excited to testify, right? He talked about that. It was terrifying for him. But an otolaryngologist, I'm sure I am mispronouncing that. He's a specialist at that point, called him by St. Pete's, right? Strangulation can result in death. This seems to be a very accepted premise. Strangulation can result in death, not one really for argument. He says that there was air in the esophagus. They didn't scope it because they were worried that there was a tear in the esophagus, so they're not going to put a scope down there and increase that danger. That air is from damage to the throat, not from compression to the chest, not because somebody, she fell down and people landed on her. That's not where that happens. That happens below. And the air that he saw was higher up in the throat area. He said it's better in 24 hours, but he can't say it's gone. Remember what he said? Like, it had not gotten worse, but it wasn't gone. And he can't say it's gone because we don't do that kind of exam for that. We don't want to put that much radiation into this very small 17-year-old. Dr. Stankus is an ER doctor. She testified for the defense. She said pneumomediastinum. She agreed. It can certainly result from strangulation. She agrees that the standard of care for pneumomediastinum the air that was higher up in the chest, to admit the hospital for observation and retesting. We don't send those folks home, right? It's not benign. It's not a mole. That was her example of something benign. We don't send those folks home. If you present with pneumomediastinum, especially as the result of strangulation, you're getting admitted, and we're going to watch you because it absolutely is dangerous. And Dr. Kim said, I had significant concerns. We were worried about her. That's why we admitted her. And Dr. Stankus agrees. Strangulation can result in death. Then you have Dr. Gilbert's testimony, and she talked about being a child abuse specialist and a 30-year medical practice. And she gave all of those strangulation effects on the body that we've previously talked about. She talked about that jugular vein occlusion. Remember, 4 pounds. That's that lack of ability to remove the deoxygenated blood. 4 pounds of pressure. It takes about a minute to lose consciousness with jugular vein occlusion only. 20 to 30 seconds for petechia, 3 to 4 minutes for death, if there is only jugular vein occlusion. Carotid artery occlusion, slightly different. Greater pressure required for carotid artery occlusion. 11 pounds of pressure, you lose consciousness in 20 to 30 seconds. Death is anywhere from 1 to 3 minutes. It's a range, right? You can't say specifically, but it's a range. And she talks about that. She said, when a carotid artery occlusion, you're going to see more global result. You're going to see loss of consciousness. You may see seizures. Then you move to brain death or death and a loss of muscle tone. When Dr. Gilbert watches that video, she says, I believe that I see a seizure. There's a moment right after or right before she loses consciousness that her arms, I believe she says, flail without any movement. And prior to that, there's some significantly focused intentional movement. And then there's a moment of flailing, and then she goes limp. Fatima goes limp. Caleb says, that's the word he uses. Isaiah used, she like frizzed, and then she went limp. So what are those kids describing to you? They're describing a difference between the moments where she is fighting, Fatima is fighting for her life, right before she loses consciousness. And I submit to you that is a seizure. And that is what Dr. Gilbert watches that video and believes she sees. She said, we can't test for it. That's not the kind of testing that we're able to do, but I submit that's what I see. And that is consistent with what the science says. It's consistent with what the witnesses observe. So how do we know that we've gotten to the carotid artery occlusion? Because about 30 seconds in that 20 to 30 second range, when you watch the video, that is when Fatima loses consciousness. So we know we don't have solely jugular occlusion. We also have carotid artery occlusion. He is imposing enough force on that child's neck to create significant damage, great bodily harm, and the likelihood of death, but for the interruption. And that death can happen in 1 to 3 minutes. Tracheal occlusion results in the lack of oxygen to the brain, that buildup of pressure. And again, Dr. Gilbert describes there's going to be immediate panic. You've got that CO2 buildup that's telling your brain that you have to breathe, and then it results in death. She describes observing the pneumomediastinum, the subcutaneous emphysema, that air in the throat. And anytime there is obstruction of either blood or air to the brain, it is a life-threatening injury. So Exhibit 72 and 103, the petechia described, you have synovia brevis on the left-hand side. And how do you know that it's petechia? Because it doesn't exist a couple of days later. 3 days later, it has resolved itself in Exhibit 103. And that is the distinction right between those two. October 21st, the photos show the bruising and scratches that cover from the left to the right side of her neck, consistent with the arm placement and pressure for her carotid artery, her jugular vein, and that tracheal occlusion. And you see that all in that space right there. Again, Exhibit 74, same, these are 3 days later. The bruising and the scratch is consistent to the front of her neck, where Fatima is scratching and clawing at her dad's arm to get it off of the front of her neck. That's the tracheal occlusion happening there at the front. Remember, your carotid and your jugular are on the side, and your trachea runs right down the center. Exhibit 81, the side of her neck, and that bruising goes all the way over to the back side of her neck. Again, consistent with the arm hold that is described by all of the witnesses leading up to that point, right? This is all of this bruising is the result of that, and that right arm and left hand in a chokehold from behind, and pressure for the carotid artery and jugular vein occlusion. So then element 2, again, force or means to produce bodily harm or death. Those symptoms reported in that video evidence tells us, based on the time and those symptoms experienced, that all 3 of those occurred in this case, which means the amount of time it takes to inflict the probability of death is grossly shorter. The force used would have resulted in great bodily harm or death if not interrupted. No injuries to her head are noted by medical staff or reported by her. Defense counsel, I believe in his cross-examination, said, well, if they hit that tree, couldn't this have happened? Couldn't this have happened? What if all of those symptoms are consistent with a head bump? And Dr. Gilbert said, some of them are. Not all of them, no, but some of them are. But also, I did a head to toe in none of those. There's no bumps on her head. There's no bruising. There's no tenderness. Clearly, there's no medical symptoms or science to indicate in any way that she struck her head. All of her injuries and damage is to her neck. All of the symptoms she experienced flow directly from that damage. And that's it. Element 3, acted with the intent to inflict great bodily harm. He's acting in anger for her defiance. That is intentional. That is what Ihsan Ali is doing. He holds her in a rear naked choke for just under a minute, and he is squeezing hard. He knows she is fighting. He knows she is struggling. He knows she is gasping for air. He knows that she is grabbing at his arms. And then she goes limp and stops fighting. But despite that, he continues to strangle her. So you know he is acting with that intent. He's ignoring the strikes and the screams of the kids. They are punching, they are kicking, and it has zero effect. It does not impact or change his behavior in any way. And that is an extended period of time. We know that he already has his arms, in fact, around her neck when they go down to the ground, and he doesn't throw his arms out to catch himself. He's going down with her, and he's going to hold on to her neck no matter what happens to her in that process, from the beginning to the end. Because at the point that he grabs her by the neck, he is furious. And that is what he's acting with the intent with. It's not to restrain her. It's not to do any of those things. He is now just a grown man strangling a child because he is angry that she has defied him. He's only released Fatima when he is forced to do so by other adults. When you go back to that family household member, that is your B1 special verdict form again. Nothing has changed. Back to physical discipline, that force used as lawful is defined, reasonable and moderate, restraining or correcting, and viewed objectively. So why does this not apply? Well, it applies for charged and lesser offenses. You're going to see that, and you have a whole range of instructions in there about lesser offenses. First, it must be your child. Okay, he meets that. It's his child. It's not somebody else's child. Must be for the purpose of restraining or correcting. It fails immediately there. None of this contact at this point for the assault in the first degree is for restraining or correcting. It is punishment. He's intending it for punishment of this child. Ihsan is angry. He may have gone to the bus stop to get Fatima and take her home, but by the time he grabs her, he is no longer doing that for the purpose of correcting her. I think one of the primary tenets of parenting is that if you are so angry you can't see straight, you do not engage with your child. You walk away. You don't attempt restraint. You don't attempt correction because you are no longer acting in a manner that is for the child's purpose. By the time you make contact with that child, you are doing so for your own edification. That's exactly what is happening here. Parents don't correct children by strangling them. Parents don't correct children, restrain children by strangling them. It has to be objectively reasonable and moderate. You are deemed to be reasonable people. That's why you're sitting here. It has to be objectively reasonable and moderate use of force, and that is not what occurs in this case. It is unreasonable to strike a child with a closed fist or interfere with their breathing. The medical evidence proves that his acts interfered with her breathing. You have to consider the size, age, and condition. We heard that Fatima's 5'1", 100 pounds, maybe soaking wet. She's a small person. She might be 17 years old, but she's a small 17. And she is certainly grossly smaller than her father. We also heard the testimony of Tracy Arnold. This day occurred. Remember, Fatima's been home being online. She's not been at school since about September 17th. So they haven't seen her in about a month. And Tracy Arnold, she looked thinner, way thinner than the last time I saw her, and much more frail. So I submit to you that Fatima is particularly vulnerable. She already was with her size, but even now more so than she was just 4 weeks prior. And we also know that Fatima's throat is particularly vulnerable as a child. And Dr. Stankus' testimony on behalf of defense also said, yeah, I mean, children obviously are smaller. It's easier to do damage to their windpipes. It's easier to do damage to their necks. She might be 17 again, but she is a small 17. And as a child, she is already more vulnerable than, say, an adult male, right? That placement of that force is extremely dangerous for those jugular veins, the carotid arteries, the trachea, and the spinal cord in the back of the neck. And all of the medical folks talked about that. You have an instruction in there that is very wordy, because again, we're lawyers and that's how we put things in a narrative. But I'm giving you a picture, okay? You start with assault in the first degree. That is what you evaluate first. You do not move on to any other instruction and evaluate it until you have completed assault in the first degree. If you have evaluated and deliberated on assault in the first degree and you agree unanimously that he is guilty of assault in the first degree, you stop. You don't address assault 2, you don't address assault 4, you stop. Your inquiry is done. If you're like, man, I don't know, then on assault 1, then you move over. Whether it's unanimously not guilty or you're unable to reach a verdict, then you go to assault 2 and you start that process over again. I will tell you that as you go through, you may well say to yourself, well, these two are easy. These two are really obvious. We'll just do those instead. You don't get to. Your instruction says you do assault 1 all the way first. And then if you are unable to complete that, then you move to the other 2. You work your way down, right? But otherwise, your inquiry stops if you all agree unanimously that he is guilty of assault in the first degree. Same thing. Do not begin that analysis until you've reached a decision on assault in the first degree. So then we go to assault in the second degree, that lesser included. When someone intentionally assaults, as it relates to Ihsan, when the defendant intentionally assaults another and thereby recklessly inflicts substantial bodily harm or assaults another by strangulation. You now have the definition of reckless, knows of and disregards a substantial risk, and that disregarding is a gross deviation from conduct a reasonable person would exercise in the same situation. And I'm going to show you a ladder here, that mental elements ladder. So remember, we talked about if you do something intentionally, then you've done it knowingly. If you've done it knowingly, then you've done it recklessly. So it's a when recklessness as to a particular fact is required to establish element, it is also established if a person acts intentionally or knowingly as to that fact, right? And that makes sense, because if somebody has disregarded a standard of behavior that is expected, and that is a gross deviation, then we presume that you did so knowingly. I'm sorry, if you've done so intentionally and knowingly, then we presume that you've also done so recklessly, right? It's incorporated therein. So substantial bodily harm, a temporary but substantial loss or impairment of any bodily part or function, or a fracture. And then you have the definition of strangulation, to compress a person's neck obstruct the person's blood flow or ability to breathe, or do so with the intent to obstruct the person's blood flow or ability to breathe. It's a really obvious, I submit, definition, but we have to give it to you anyway. So count 2, assault in the second degree. These are your definitions. We'll come back to the bottom paragraph, but you essentially have to decide A or B, 1A or B, and you don't have to be unanimous about 1A. So as it applies, same information for October 18th, 2024 in the state of Washington. None of that has changed. So 1A, intentionally assaulted. There are 2 ways that you can, Ihsan Ali could have done this under the assault in the second degree. 1A, he intentionally assaulted and thereby recklessly inflicted substantial bodily harm. So the evidence you have of the intentionally grabs her twice. This is not an accident. He grabs her the first time and then he grabs her the second time. That moves into that rear naked choke with sustained pressure. Kids are pulling so hard that they have to dislodge him, that they have ripped his jacket. And regardless, he maintains his hold throughout. That is intentionality. Can't breathe is a temporary but substantial impairment. Losing consciousness is a temporary but substantial impairment of any organ or function. If you cannot breathe, if you have cut off air to the jugular veins and the carotid artery, or excuse me, blood flow, jugular veins and carotid artery, you have temporarily but substantially impaired their ability to function the way that they are supposed to. If you have cut off the airflow because you've crushed the trachea or closed the trachea off so the air can't get through, that is a temporary but substantial impairment because that bodily organ cannot function. If you have lost consciousness, your brain is not working the way it is supposed to. It is a temporary, even if you regain it, but substantial impairment because you are intended to stay conscious. That is what your brain is supposed to do. And his behaviors have impacted her ability to do so. Sore pain, sore, painful throat, difficulty swallowing that she describes well after the fact, temporary but substantial impairment, those changes to her voice, those changes to her motor skills, her ability to get up and move around. You heard that described, that loss of muscle tone, temporary but substantial impairment. And then you have all of that bruising along her neck. By definition, that is temporary but substantial disfigurement. That is not how she appeared prior to. And we're looking at 3 days later and it's scratches and that bruising is still there, those abrasions. So then strangulation, 1B, exhibit 34. You see him grabs at her neck twice. It's not an accident and refuses to release. You see, again, that's the same pressure. A lot of that information is the same for strangulation as it was for 1A. You have that her face changes color. You have all of that bruising. You have the medical reports and the nurse's testimony. And you have that she can't breathe. Again, doctor reports, nurse testimony, and medical reports. So all of that information is the same for 1B. You're going to consistently have overlap in the evidence between many of your charges. When you go to do that evaluation, you have to all unanimously agree that either 1A or 1B occurred. You do not have to agree which of 1A or 1B it is to find that element number 1 has been met beyond a reasonable doubt. Okay? And then BB1, family household member, again, exactly the same. When we talk about count 2, as it separates itself, the lesser included for assault in the second degree from assault in the first degree, the initial placement of dad's arms around his daughter's neck and the impediment to her breath, that strangulation is complete. That's it. Assault second is done. As soon as he puts his arms, there's no requirement for loss of consciousness. There's no requirement for any of these other things to do. For strangulation, all he has to do is impede her breath. And the moment he puts his arms around her neck and you see her standing there grabbing at them before they've even gone to the ground, assault in the second degree is completed. That extended hold of her neck is what distinguishes assault in the first degree from that assault in the second degree. That is why that is not merely assault in the second degree. It is also, but it is not merely. So that's where we were. Back to your roadmap again. If for some reason you're stuck on assault in the second degree, then you go back through that same process. If it's guilty, you stop. If it's not guilty, unanimously, or you are unable to reach a unanimous verdict as to assault 2, then you go to assault in the 4th degree. So there's that definition for assault in the 4th degree. It's simply committing an assault. No bodily injury required whatsoever. Nothing changes for counts 1 and or elements 1 and 2. And the back half of element 1 then, as it relates to Ihsan, simply that he assaulted Fatima Ali. The touching is harmful. We have all of that testimony of the parents, of those present, the kids, Mr. Denicola, the Wagners, all of the doctor and the medical. And then we have that the touching of Fatima is offensive. She's fighting it. She clearly doesn't want to be touched like that, like how he is touching her. There's no injury required for assault in the 4th degree. So yes, obviously assault in the 4th degree has been met by the evidence before you in this case. And then BBB 1, that's your family household special verdict form again. And that's where you end up. So last count for dad assault in the 4th degree as it relates to Isaiah. That definition is, we talked about those elements. They are exactly the same as that lesser included was for Fatima, but now it is for Isaiah. We all are likely to agree that none of this information has changed and is not at issue in this case. It is October 18th. That is Isaiah Williams, state of Washington. So what evidence do you have about the assault 4 of Isaiah? That touching of Isaiah is harmful. You have the video of Ihsan punching Isaiah earlier in Exhibit 34. You have those still shots from Exhibits 8 and 9, 8 and 9 of him punching Isaiah in the head. Not simply a shove, not simply a push, but a closed fist punch to the side of Isaiah, his temple. And then you have the Exhibits 39 to 51 showing his injuries, that redness, bump, the pain. You have Officer Beltran described seeing that in person and taking those photos. And you have that testimony. And also, you saw Isaiah. It's physically much, much smaller than Ihsan. And you saw him when he was present here, and you see him in the video. They are not the same size individuals, right? And you know that touching is offensive. First of all, I submit to you punching anyone in the head, unless you are engaged in a boxing match, which you've signed up for, is offensive, right? Punching a child in the head is particularly offensive. Notably, no injury is required, but it exists here. There is that bump, that redness, and that swelling and that bump to the side of Isaiah's head. And you see it there, consistent with where he says he is struck and with where you see Exhibit 51, that closed fist strikes him in that bus video. So then you also have the self-defense instruction that is given to you for Ihsan, saying, well, I'm forced essentially to do this, and the state has to disprove that. So as it relates to count 4, force used by a person who reasonably believes he is about to be injured and the force he uses is not more than necessary. The person using the force may employ such force and means as a reasonably prudent person would use under the same or similar conditions as they appeared to the person, taking into consideration all of those facts and circumstances known to the person at the time of and prior to the incident. Then you have a definition for necessary, as they reasonably appeared to the actor at the time. Not as he claims that they appeared or he'd like them to have been, but as they actually reasonably appeared. That there's no reasonable, effective alternative to the use of force and that the amount of force used was reasonable. And you have that in your definition. There's no duty to retreat, to be very clear. If somebody is attacking you, you are not required to retreat. But still, there's the requirement that the lawful force be not more than is necessary. You don't get to do whatever you want, plainly. There are limitations on what force you get to use in response. You also cannot be the person that physically instigates that interaction in order to create the likelihood of provoking a belligerent response from someone so that then you can use self-defense after the fact. And you have that instruction there as well. So why is this not self-defense? Start first, that force is not lawful. does not reasonably believe that he is about to be injured when he strikes Isaiah. He is not striking Isaiah to himself. That's not what he is doing. And you'll look at those photos and you'll look at that video again. He is striking Isaiah to prevent Isaiah from interfering any further in his mind with what he gets to do to Fatima. It is objectively unreasonable what he does to Isaiah. He is grabbed at the point that a strike hits. You know, watch that video. He has already grabbed Fatima by the hoodie and he is dragging her by her neck into the dirt. And Isaiah's trying to pull him off. Isaiah's not striking him. Isaiah's literally trying to disengage Fatima from her dad, who has her by her hoodie front collar and is pulling her forward. It is already choking. That has already started. That is an unreasonable means of restraining your child, I submit. And Isaiah said, it isn't just like grab her, like, let's go home. That's not what happens. He's like, he grabs her aggressively. And remember that Isaiah has known Fatima at this point for a couple of years. And he says, I know Fatima. I know what she goes through. And so he is anticipating that this is not simply a, let's go home and have a sit down family talk about it. He is concerned deeply for what might physically happen to Fatima. And almost immediately, when she's getting ready to go, Dad grabs her by that hoodie and starts dragging her. And Fatima says that. It is, as we saw from the parental discipline, our laws recognize that it is objectively unreasonable to throw, to strangle, or punch their own children with a closed fist, let alone someone else's child. And that's when we give more leeway to parents, right? If you look at that video, he's not striking, Isaiah is not striking Ihsan. The evidence does not support that finding. And we talked about the size of Ihsan compared to 16-year-old Isaiah, who is 5'5". He didn't know how much he weighed, but I submit to you, he's a pretty thin kid. He's not a big kid. And he's also not punching a grown man who is in the middle of throwing a punch at him. That force used by any objective standard is unreasonable. You heard Elijah just thunk. It's like, I heard that thunk when it hit. He's punching Isaiah in the head with a closed fist. It's not okay to do that, especially not when and how that punch occurs. It is for the purpose of neutralizing Isaiah. He can get to Fatima. It's not for protecting himself. It's not self-defense. Ihsan has created this situation. Isaiah did not. Ihsan's intentional actions were reasonably likely, I submit to you, to provoke a belligerent response from those present. Isaiah to be closest and have the most background information. We talked about that. And from the get-go, Isaiah is trying to assist Fatima, who he believes to be in physical danger. And he's right? And notably, when you look at this self-defense instruction for defense of others, Isaiah is entitled to protection under the same legal principles. So if anyone is entitled to defend themselves, it would be Isaiah. Those strikes by Isaiah on Ihsan do not occur until Ihsan is already strangling Fatima on the ground. There's a lot of, well, he hit him like 42 or 32 times, whatever number defense counsel proffered. That doesn't happen until after the fact when they're already on the ground. Isaiah has not struck Ihsan when Ihsan punches him in the head. There is the initial, and you'll be able to watch it in Exhibit 5. There is the initial contact, and when you look at that video, when you look at those photos, you'll see he's already dragging. He already has a hold of Fatima by the front of her hoodie collar, which is what Fatima describes, and Isaiah is trying to pull them apart. And see, there's another example of Isaiah, Ihsan dragging Fatima by the front of her collar, and she is pulling back, and Isaiah is trying to dislodge them. Exhibit 6. You go to Exhibit 7. All he is doing here is, again, trying to get him to let go of his daughter, who he has by the front of her collar, and is throwing her on the ground. That is what Isaiah is doing during the course of this interaction. And now Fatima's down. He's thrown her on the ground. And look at what Isaiah and Ihsan are doing. Isaiah's hands are out. They're out in the, what are you doing, man? What is happening? Oh my gosh. His hands are down by his side and they are out. And what is Ihsan doing? He's grabbing him by the front of the collar and then bam. And look at Ihsan's face. Does that look like the face of an individual who is protecting themselves? Or does that look like the face of a guy who's real angry? Real angry that this kid had the audacity to interfere with how he has decided he wants to parent his child. I submit to you that's exactly what that face is. That has nothing to do with protecting himself and everything to do with exerting his anger and his power and control over this other child that is present. He's not being attacked, he's being thwarted, and he's being interrupted, and he doesn't like it. It's happening because Ihsan is mad. The force he uses is neither reasonable nor is it moderate in this case. It is not a necessary use of force in either the timing of when it occurred to protect himself, nor is it a necessary amount or reasonable amount of force being used.
That's not me. Of course, it's them. They always doing this.
Her away. Mom is not giving aid. Mom is not asking if she's okay. Zayla says she's just trying to grab her and she's grabbing her by the throat. Athena immediately knows it's wrong and she says so. Like, what are you doing? Mr. Leary asked her a question about whether it's mom or sister, and you remember you heard Athena go, "It's mom," and then she goes, "Well, now that you're asking me and pointing the video, I'm not sure if I know if that's mom or sister." But she is correct. We know from the video it's Zara. Visible standing away from Fatima. So we know that Penny never puts hands on Fatima. As far as the video shows, we know that it's Zara the whole time, and Athena is correct. So yeah, the child, again, got confused in terms of the direct examination questionings by Mr. Leary, but you watch the video and you know that she is right. She says, "Mom grabs her by the throat." And I said, "What are you doing? You can't do that," because she just watched it happen. Even Athena, who has no medical training whatsoever, knows that that is not proper. And mom has done that. And she is correct. And then you have the testimony that Zara's, she's holding on to her by the throat to both keep her from fleeing and to continue those efforts of dad. And Fatima is fighting that as well. There's no indication by anything that we've seen in terms of evidence that somehow Zara is below average intelligence or has some sort of eyesight problem. Nothing that interferes with her ability to perceive what everyone else testifies about over and over and over again is clear and obvious. Even to Josh Wagner, after Zara is already on scene, right? She knows that her daughter is unconscious. She knows her daughter is injured because they were her arms helping to do it. And she doesn't ask if she's okay. Just let me talk to my daughter. Those are grossly different response, and you saw the video of that. It's a grossly different response for the arrest of her husband and the strangulation of her child. And let's be clear, the state's not saying that there is some sort of anticipated, expected response, that everybody's response to an emotional situation has to be a particular way or it has to be consistent. We know that that differs from person to person. But when we're talking about Zara's response for the arrest of her husband compared to the strangulation of her daughter are demonstrated by Zara on body cam to be grossly different. And then we have the strangulation, the medical reports, the doctor and nurse testimony. So the physical discipline defense for Zara is the same analysis as it was for Ihsan. It is unreasonable to interfere with a child's breathing. That is an inference that you get to make based on that description. Nothing changes about the size, age, and condition of the child. And nothing changes about the location of the injury to Fatima. And that's same special verdict form for assault in the second by Fatima, or for Zara on Fatima. Count 4, burglary in the second degree. Burglary in the second degree occurs when you commit the crime of entering or remaining unlawfully in a building with intent to commit a crime against a person or property therein. That's the definition. Then you have the definition of enter or remains unlawfully. That is again in your instruction packet. You enter or remain unlawfully in or upon premises when you are not then licensed, invited, or otherwise privileged to enter. So enter or remain. Guys, that also means that when somebody has trespassed you from what otherwise would be a public place, that means that you are no longer licensed, invited, or have the otherwise privilege to so enter and remain. Instruction number 44, a person who enters or remains unlawfully in a building may be inferred to have acted with intent to commit a crime or person therein. This inference is not binding, and you decide what weight, if any, to give it. That means the state does not have to also charge underlying offenses and also prove those beyond a reasonable doubt. You get to infer, if you so choose, as to the defendant acting with the intent to commit a crime against person or property therein. And then there are your elements. October 18th, entering or remaining, state of Washington. This slide probably looks very familiar. Again, it doesn't change. Elements 1 and 3 happens on October 18th. It happens in the state of Washington. Backside of element 1. Unlawfully in a building. How do we get to the point where she's unlawfully in that building? You heard the testimony on September 16th. That incident occurs with Isaiah campus. You hear that Celeste Walter corroborate that, and as a result, I trespassed Mrs. Ali from campus and all North Thurston School District property. You heard the testimony of Ms. Waltermeyer and Officer Howard on September 17th. Haneen comes to try and pick Fatima up early from school, and the school says she needs to stay and you need to tell your mom to come have a meeting with us. So later that afternoon, Zara returns. She meets with Celeste. She meets with Officer Howard in Celeste's office and is presented with that trespass order and those instructions about the order by Officer Howard. You have further that when Zara returns and they serve her with that trespass order and she's given those instructions, Officer Howard offers Zara the language line. And you heard what the language line is. The language line is, if you don't understand the document that's been provided to you is in English. If you don't understand or you're not comfortable with that, we can provide you assistance. Would you like someone who speaks Arabic directly to be on the language line and have this conversation with us? You can choose to take it, you can choose not to take it, that's your choice. Zara declines the language line. She does not want the language line. Instead, she asks for Haneen to come assist. So Officer Howard and Celeste say, sure, we'll wait. So in the meantime, they're chit-chatting with her in English about a number of topics. And then Haneen, Zara's request, arrives and they go over the order a second time while Haneen is present and assisting. You hear the testimony that she's offered chances to ask questions. She is specifically identified to her the places she can and can't go. You can't go to the baseball field. You can't go here. You can't come to the building. You can't come to pick up your daughter. It's fine for Ihsan to come pick up. It's fine for Haneen to come pick up. This only applies to you. You are not allowed to be on the property, period. She has a chance to ask all of those clarifying questions about the parameters. She's given the phone number to call if she has any further questions. Defense counsel said, well, there's nothing on there that says she can appeal that decision, right? There's no requirement. And you're not going to find it in your instructions anywhere. It doesn't exist. She is given a sheet that describes what she is to do. She's been orally advised twice with the interpreter of her choice. She speaks English, to be clear. It may not be her first language, but there are consistent interactions with English. No one's saying that her English is great, but it is certainly enough. You heard Fatima's testimony. They've lived in the United States since Fatima was 6. So we're at 11 years at this point. And Zara is able to communicate in English with these women, and she has done so consistently, and that is described. But even with that, she asks for Haneen to come, they wait for Haneen, and they go through all of this. And that phone number is pointed out and identified. Here, if you have further questions, then call this number. And per Ms. Waltermeyer, that never occurs. There's no questions about it. It is a clear, it is a self-explanatory order that is accompanied by oral explanation. And then you have that trespass letter itself at Exhibit 121. Then on October 18th, she violates that order. She enters or remains unlawfully in a building because she is not allowed to be in that building. You have that she arrives on campus where she's already expressly been told not to be. She understands that. Moreover, Haneen, the person that had that conversation while she was present, is with her. So Haneen knows as well. She's not there by herself. Then when Fatima escapes from the stranglehold, she chases her into the main office inside the school building where she is not allowed to be. She not only goes into the building, she goes into the office and tries to continue to go through the back. And you heard Tracy Arnold say, I had closed those doors and I was using my weight to try and hold those doors closed because I could still hear her and Denise Kinley yelling back and forth. She then leaves, and you see her in the video try and go through the side doors, and Principal Dean cuts her off. That intent to commit a crime, the entering or remaining is with intent to commit a crime against a person or property therein. She knows husband of just strangled is in there. She has demonstrated at this point her ability to physically assault a child. She knows Isaiah. She chased them. She ran after them. And we've heard it over and over again. In her story, there's no evidence to support that whatsoever. If anything, Isaiah is a kid in the story that everybody would, I think, like to have as their kid. He is kind. He is respectful. He is there to help out friends and look for danger to people that he knows are particularly vulnerable. And he demonstrates that on the stand. But she blames him and his family for everything. I submit to you, you heard from Victor Barnes. Victor's Isaiah. Listen, we tried to engage. We tried to have a reasonable conversation. We tried to be respectful about what the parents wanted, what Ihsan expressed he wanted. And so we said, you guys can't see each other. You need to take a break, right? And he was not like over dramatic by any means. He said, I understand that parenting is hard, right? Everybody agrees that parenting is hard. I think everyone would agree that parenting teenagers is not for the faint of heart. It is difficult for sure. And we've talked about that at length. But this goes well beyond that. And Victor says, I understand it's difficult, but you know what? They're teenagers and they're in love, or they think they're in love at least. What are you going to do, right? So we put some boundaries on it. We put some guidelines on it, and it didn't pan out. And this was the response. And for Zara, that is all Isaiah's fault. That is his fault, his fault, his fault. And so what is she doing? She knows there's a no contact provision. So what is she doing when she goes in there and chasing him in? She knows she's violating that order, and she intends to violate that order. She knows she has that with Isaiah. She has to stay 1,000 feet away, and she knows that he is in there because she watched him go into that building. The intent to commit a crime against a person or property therein. Again, I don't have to prove, you don't have to find what crime the defendant acted with the intent to commit therein. That's not in your instructions, and you're not going to find it because it doesn't exist. It could be any number of them. A further assault of Fatima, an assault of Isaiah, a further violation of the no contact order with Isaiah. You must only determine that the entry or remaining within the building was with the intent to commit a crime, but you need not actually identify that that crime has occurred. So there we know she's going in the building because she's actually in the building, right? Exhibit 110, page 6. We know she's in the office itself because there she is, bottom heading towards those back doors. There's Tracy Arnold, exhibit 111, page 9, running through to try and get in front of her because as she said, when she closed those glass doors at the front of the office, main office, Mrs. Ali goes around her. And there she is yelling at Miss Kinley and arguing. Page 11. And still arguing with Paul Dean in front of that campus expectation sign. We know she's not allowed to be. Now, mind you, the burglary doesn't happen until she enters a building. The burglary itself is not for simply being in the parking lot or on the property. The burglary happens, in this case, when she enters the building, because that is the definition. Okay, so just make sure you make that distinction. Last crime, we're almost there. Count 5, violation of that no contact order with Isaiah Williams. So violation of the court order, you commit the crime of violation of a court order when you knowingly know of the existence of the order and you knowingly violate one of the provisions that's identified within that order. And you have, again, that element instruction in your packet. 4 elements altogether. We're going to go through those elements with the evidence that you've seen for each of those elements. 1 and 4, seen this, same instruction, right? Don't anticipate argument or significant argument, but you still have to find that the state proved it, and you have to find the state proved it for each count that exists, okay? So the court, here's the order, Exhibit 36, page 1 that you have. You have the court that has issued that order. Let me go back up for 1 second. There existed a protection order. So let's look at the back half of element 1, existed a protection order. Exhibit 36, page 1, you have the court that has issued that order, Superior Court of Washington, Thurston County. You have the protected person or the petitioner, Isaiah Williams. Isaiah is 16, so as a parent, I have to petition on his behalf to protect him. You have Zara as the respondent. You have the effective date until October 24th at 9 a.m. And then you have this order restrains, and then Zara Ali. So clearly identified as the restrained party. It's not an overly complicated order to read. Then you have section 3 on page 2. Protected minor is listed on section 3. There's your section 3 when you're looking for it right there underneath the red dot. And that order protects Isaiah Williams. Page 4, here are all of your provisions that she is restrained from doing and clearly outlined. No harm to Isaiah. And the minor listed in section 3 above. No contact with Isaiah. Clear through a third person. No stalking of Isaiah. Passing, following, monitoring of Isaiah. You have the exclude and stay away by 1,000 feet from Isaiah. His school, himself directly there under D, element D. And then stay 1,000 feet away from the listed residents, and they put in their own listed residents specifically, because by that point they know, mom and dad already know where they live because they've shown up at the house, and you've heard Victor talk about that, right? That he tried to reason with them, he tried to talk to them, he tried to avoid this, and he was unable to do so based on the way events had been unfolding because they showed up at his house. So the elements that the defendant knew of the existence of this order, you have Officer Hang's testimony that he serves that order on October 16th. Remember that it is issued, let's go back. It's issued October 14th. That's when the order is issued. 2 days later, Officer Hang serves that order. Exhibit 37, you have that proof of service that Hang files with the court. And then you have Exhibit 38, the body camera of that service. He serves it on Zara at her home. You watch that. You see that Haneen is with her at the time of the service. Again, at her request, Haneen says, "Can I stay? I help my mom." Yeah, sure. The two women are communicating with each other back and forth about that order as Hang is describing it. Zara asks questions about it herself in English of Officer Hang. Haneen also asks clarifying questions. You know they understand that Mrs. Ali, Zara Ali, understands what that order is because she demonstrates that. He, in fact, points out the number to call in the document if she has further questions. He explains it to her in basic terms. He doesn't use overly complicated terms. And it's not a complicated document or set of directives to comply with or understand how to comply with. Moreover, you see her ask that clarifying question. Wait, so if this means I can't contact him, does this mean he can't come to my house either? She understands what the limitations of that order are. Does that mean that if I'm here and he comes to my house, then he gets in trouble too? Well, What does Officer Hang say? He goes, well, if he comes to your house, like you have a right to be in your home, you can call law enforcement if that's the case, right? We know she understands the order. She asked that clarifying question. She provides alternative situations and is trying to decide how that order, those alternative situations fit into this order. So we know she understands what the limitations of that order is. And she has, again, her chosen interpreter present with her, and she's communicating with her throughout. She doesn't demonstrate at any point that she doesn't understand how she is personally restrained or demonstrate confusion about how she is personally restrained. And then you have element 3, the defendant knowingly violated that restraint provision, prohibiting contact, excluding the defendant from a school, prohibiting the defendant from knowingly coming within a specified distance of the location. So on October 18th, about 2:13 p.m., she's certainly within 1,000 feet of Isaiah. She's physically engaged with Isaiah, and she chases him and her daughter into Timberline High School, certainly within 1,000 feet. And then you have it again at 2:13. She's in 1,000 feet of his school grounds itself. So there's 2 separate provisions that she has violated. And then she knows exactly some confusion about who Isaiah says his name. She tells Hang and Bell and Chavez, you see that in their body cameras. He goes to school here. She knows where Isaiah goes to school. He's a student here. Hanina just said, Isaiah James Williams. He's a student here, I'm pointing, right? She knows exactly who is protected by that order. There's no confusion. She knows exactly where his school is. There is no confusion. She knows she's violating that provision of that order. She just doesn't care because it doesn't matter to her. She doesn't care. There's exhibit 134. There's Isaiah, where everybody starts running. There's exhibit 108, page 2. There's Fatima and Isaiah, Zara right behind with Haneen behind her, certainly within 1,000 feet there, certainly on the school grounds, while Isaiah. Page 109, again, you have them running, and I believe that's at 2:20 of that video, of the 2-minute and 55-second video. Again, you see Fatima and Isaiah. And at 2:41, 21 seconds later, you have Zara chasing after them. She's about 20 seconds behind them in her run, and certainly within 1,000 feet of Isaiah. So that is it. At the conclusion of all of your deliberation, I'm going to ask you to return verdicts of guilty on each of the charge counts and findings of yes for each of the special verdict forms for Ihsan and Zara Ali as the state has charged them. Thank you.
Members of the jury, at this time, the bailiffs will lead you back to the jury room. We anticipate a 30-minute break, but if you are not done eating lunch after 30 minutes,